The doctrine of unilateral mistake is found in section 153. The rule allows a mistaken party to void a contract if the following elements are met. 1. A party is mistaken as to a basic assumption of the contract. 2. That mistake has a material adverse effect on the consideration the mistaken party receives. And 3. The mistaken party does not bear the risk of the mistake under section 154, and one of the following applies. Either the mistake makes enforcement of the contract unconscionable, or the non-mistaken party has reason to know of the mistake, or his fault caused the mistake. Let's consider a hypothetical based on an actual case. A company is building a plant on a bayou and needs to dredge the channel leading to the plant so ships can dock at the plant. It sees an ad for a used dredger and sends a senior mechanic to check it out. The mechanic knows nothing about dredgers, but can tell if a machine is in good working order. The company does not ask the seller about the capabilities of the machine or tell the seller for what purpose it wanted the machine. After the mechanic checks it out, the company buys the dredger. What the company didn't realize, however, is that dredgers come in two flavors. One digs deep but narrow trenches for the laying of underwater cables. The other digs wide and shallow trenches for clearing waterways. The company needed the second kind of dredger, but they bought the first. The company wants to void the sales contract on the basis of mistake. So first, what kind of mistake is involved? Mutual or unilateral? Well, there is no mutual mistake. The seller knew there were two kinds of dredgers, but the company did not. Under unilateral mistake, was the company mistaken as to a basic assumption that had a material adverse effect on it? Let's say yes. It assumed the dredger was suitable for clearing the bayou, and it wasn't. Did the company bear the risk of that mistake? As we discussed in the podcast on mutual mistake, section 154 tells us a party bears the risk of a mistake and so cannot void a contract on the basis of mistake if A. The contract allocates the risk to him, B. He is aware that he has limited knowledge, but he treats that knowledge as sufficient, or C. The judge allocates the risk to him because it is reasonable in the circumstances to do so. In the hypothetical, a court could say that the company knew it didn't know much about dredgers, and rather than educating itself about the different kinds of dredgers, or hiring a broker to find a dredger that met its needs, it proceeded as if it had sufficient knowledge. Under the second prong of section 154, by treating its limited knowledge as sufficient, the company assumed the risk that the dredger was not suitable for the job. Moreover, a court could conclude that neither of the last two factors under section 153 was satisfied. The price paid was not unconscionable, and the company could always resell the machine, and the seller had no reason to know that the company was mistaken, as the company did not ask for advice from the seller, and it brought in its own expert to inspect the machine. Bottom line, it is unlikely the company could void the sale on the basis of unilateral mistake. Before we leave unilateral mistake, let's take a moment to think about a related doctrine. In an earlier module, we discussed non-disclosure under section 161b. Recall that section 161b states that there is a duty to disclose where one party knows that the other party is mistaken about a basic assumption of the contract, and failing to disclose would violate the standard of good faith and fair dealing. There is considerable overlap between this category of non-disclosure and the concept of unilateral mistake. Non-disclosure under 161b and unilateral mistake under 153 share the following elements. A. One party is mistaken as to a basic assumption of the contract. B. The other party has some kind of knowledge of the first party's mistake. And C. Failure to alert the mistaken party to her mistake violates one of the contractual norms. There are, however, two significant differences between the two doctrines. First, section 161b requires the non-disclosing party to know the other party is mistaken, while section 153 only requires the non-mistaken party to have reason to know of the other party's mistake. Second, Section 161B requires both that the non-disclosing party knows of the other party's mistake and that non-disclosure violates the norm of good faith and fair dealing, while unilateral mistake voids a contract if either the non-mistaken party had reason to know of or caused the mistake, or the effect of the mistake is to violate contracting norms such that enforcement of the contract is unconscionable. Given these two differences, it would seem to be easier to make a case for voiding a contract under Section 153 rather than 161B, primarily because reason to know, all that's required under 153, is easier to prove than the actual knowledge required under 161B. Moreover, 161B requires both knowledge of the mistake and a violation of good faith and fair dealing, where 153 only requires one or the other, but not both. There is one other difference between the two sections. Section 161B is silent as to the notion of bearing the risk of the mistake, whereas Section 153 explicitly states that the mistaken party must not bear the risk of the mistake. However, there is probably not a significant difference between the two sections on this count, because if the mistaken party bears the risk of a mistake, then under Section 161B, good faith and fair dealing probably would not require disclosure. A legitimate question at this point would be, why do we have two similar but not identical doctrines dealing with the same basic fact situation? Well, we don't have a definitive answer for that question, but one plausible explanation for the difference could be that non-disclosure under Section 161B is a kind of misrepresentation. Misrepresentation first arose in tort and only later was imported into contract doctrine, and the tort side of misrepresentation requires actual knowledge. We suspect that the requirement of actual knowledge in 161B, as opposed to the reason to know standard under unilateral mistake, refers back to misrepresentation's tort origins.